Investigations were conducted under the Competition Act, which is the enabling act that gives the authority the power and the mandate to investigate conduct, anti-competitive conduct in markets across the country. There were two separate matters, and so the penalties are two and separate. And in the first matter, we received a complaint in December of 2022, it's about a year ago now, from an SME that processes honey, that refines honey and then sells it to the retail outlets. And so the complaint basically was that this supplier, this SME, in the process of its contracts with Majid al Futtaim supermarket, or rather Majid al Futtaim Limited, which runs the chain of retailers that go by the name Carrefour, that there had been a contract between the two parties over the years, and that between 2021 and 2022, the retailer engaged in conduct that amounts to abuse of buyer power. And the specific complaints were basically reduction of prices below profitable levels at certain times below cost, which had had the negative effect on the profitability and the sustainability of the SME. And so there were various complaints, there were various deductions in the form of rebates made on these retailers' sales and on these suppliers' sales, on these suppliers' invoices. And the way that the rebates would work is that there would be monthly deductions of various amounts. At their highest, these were 12% of deductions on invoices. And so there's the invoiced amount, which is then treated to a further deduction of a mandatory 12%. The other complaint was that this refiner, this processing SME had been required to supply free cartons for each new branch that this retailer was opening, as well as make a certain payment of about 50,000 shillings. So that was a complaint received. And as I indicated, we operate under the Competition Act. And so we followed due process, ensured that the requirements of that act, of the Fair Administrative Actions Act, and of the Constitution with regard to due process were followed. And so the relevant notices were issued to the retailer, which had legal representation. And so that is the most ideal situation, where there is an oversight on how we conduct our investigations. And so this party under investigation was represented at all times and presented with the opportunity to give an oral representation, as well as give evidentiary material and written submissions. And we received all of this. And subsequent to investigations, both at preliminary analysis level and again at secondary analysis level, with due consideration not only to the relationship between the two parties, but also with regard to the state and the nature of the market where these parties operate. And so, of course, we analyzed issues of how is the market space, how do parties interact with one another, what are the market shares of these parties, and we looked into the nature and interaction in terms of how are the contracts determined, what price was paid subsequent to treatment of the rebates, the effect of the reduced payments on these SME, and so on and so forth. And so all that was taken into account, both the interaction between the parties as well as the market that the parties operate in. And I would also want to highlight that we received communication from the retailer and the supplier in the course of our investigations upon just shortly before conclusion of our investigations, that the parties had a sit down and had a discussion and had agreed that the matter be settled between them. And while the authority is very open and indeed encourages settlement negotiations under Section 38 of the Act, the provision at Section 38 is very clear that any settlement must be between the authority and the party under investigation. And so an invitation was made, a call was made to the party under investigation to present itself before the authority and have a negotiation discussions. There was a delay, there wasn't an immediate response to that, but much later, and that will be in the statement that will be shared, much later we did receive overtures, efforts to negotiate the matter, but in view of the prevailing circumstances, the fact that this conduct was ongoing and continues to be ongoing, the consideration of the impact of this conduct on the party, on the supplier, that is, and the reality of having investigated previously matters of abuse of buyer power pertaining to this retailer, and finally the reality that at the time the authority had received further complaints of similar conduct, the negotiations were not fruitful or reached an impasse, and as a consequence then the authority progressed because there must be due attention given to the effect of anti-competitive market, continuing anti-competitive market on not only just the players in question, but also on the economy as a whole. And so that is the matter of one of the complainants at Woodlands. The second matter relates to Pwani Oil Limited, and of course this is a manufacturer of various fast-moving consumer goods, and we received a complaint in August of 2022. Similar conduct had been engaged in, the only difference being that with Woodlands there was a claim that there was a requirement that Woodlands post its employees to work on the retailer's premises. But the remainder of the facts are similar in terms of deduction of rebates, in terms of refusals to negotiate the rebates, in terms of requirements for free supplies, and so on and so forth. But the only difference is that the authority in March of this year issued what we call a cease and desist order, interim orders under Section 37 of the Act, requiring that this conduct cease pending conclusion of investigations by the authority. And shortly after service, Gazette notice of that cease and desist order and service of the same on the party under investigation, the party under investigation proceeded to terminate the contract between itself and the complainant. And we proceeded with investigations up to conclusion because now there was a further complaint, unilateral termination of contract, which is conduct in abuse of buyer power, where the buyer actually has buyer power. And so this matter was concluded in the same way as Woodlands. Of course, the circumstances are different, and so the considerations were different. But suffice it to say that there was a determination that a penalty be imposed, as well as certain other requirements on the retailer, including a behavioral remedy, that a requirement that they amend their supply contracts. And so just to reiterate that due process has been followed in this matter, as in all matters that are under investigation by the authority, and we have arrived at today's determination with a very keen eye on due process. Thank you.